Hi, I'm Chris Saeed, Los Angeles hit and run attorney. Welcome to CBS Law, where we deliver results, not promises. Let's talk about hit and run cases. First, I'll go over the most common hit and run charges. Second, I'll go over common defenses we employ every day for clients charged with hit and run. Third, I'll go over common sense measures you can take if you find yourself being investigated or charged with hit and run. First, the most common hit and run charge is a violation of Vehicle Code Section 20,002. Now, that's a misdemeanor. And what constitutes a violation of that misdemeanor crime? First, that someone got into a car accident. Second, that there was property damage that the driver knew or should have known occurred. And then third, that the driver of the vehicle failed to pull over and provide their contact information to the owner of the property, or if the property owner is not present, like for example, when someone hits a parked car, the driver is supposed to leave their contact information in a conspicuous place, like on a card left on the windshield, and then alert the police immediately. Now that charge of Vehicle Code Section 20,002 is a misdemeanor that carries with it up to 180 days in county jail at halftime. Now, the second most common charge that we see in hit and run cases is a violation of Vehicle Code Section 20,001. That's a crime of hit and run resulting in injury. Now, what constitutes a violation of hit and run with injury? Well, first, that someone was driving a vehicle. Second, that they got into a car accident. And as a result of that car accident, someone was hurt. Third, after getting into that car accident, the driver is supposed to then pull over and provide their contact information to the driver or occupant of the other vehicle, or if they can't safely do so, to immediately call the police and alert them to what happened. Now, a violation of hit and run with injury is a wobbler offense. What that means is it can be charged as a felony or as a misdemeanor. If it's charged as a felony, the potential consequences include a low term of 16 months in state prison, a middle term of 2 years in state prison, or a high term of 3 years in state prison, all at halftime. Halftime means you can only serve up to 50% of the time to which you've been sentenced. If a violation of Vehicle Code Section 20,001, hit and run with injury, is charged as a misdemeanor, the maximum punishment that one could receive upon conviction would be 364 days in county jail at halftime, which means the most they can do is 182 days in county jail. So a little known fact about hit and run charges, whether it's the felony hit and run with injury or the misdemeanor hit and run with property damage, is that oftentimes law enforcement will have evidence of the vehicle involved in the accident or the collision, but not the identity of the driver. And why that's so important is the prosecution can't charge a car with a crime. They can only charge a person with a crime. And that leads me to common defenses that we often employ in hit and run cases. What we find is that the police have evidence of a particular vehicle that was involved in the collision, whether that be a description of the vehicle or even the license plate. But oftentimes the police don't have evidence regarding who is driving it. They have their suspicions. They're going to look up who's the registered owner of the vehicle, or they got a description of the driver of the car. But generally speaking, they don't have solid evidences to the identity of the driver, at least enough to allow for charges to be filed. And so what they're often going to try to do is to contact who they suspect was driving the vehicle. Common defenses we successfully employ include, well, first, we're going to assert your right against self-incrimination. We're going to make sure that all communications from law enforcement have to go through our office, so no one can contact you directly. Second, we often find alibi witnesses. In other words, oftentimes someone who owns a vehicle wasn't actually driving at the time of the collision, and so they were somewhere else. Now, there's no duty on a person to give information over to the actual identity of the driver. Rather, we're focused on protecting our client. And so that means interviewing witnesses that were with them at a different location at the time of the crime, or finding literal substantive evidence that they were someone else, like receipts at the restaurant, plane tickets, etc. Now, common sense measures that you can take if you find yourself being charged with or investigated for hit and run, whether it's hit and run with property damage or hit and run with injury. Well, first and foremost, don't talk. Don't talk to the police. Don't make a statement to the insurance company, and certainly don't post anything online. Second, most importantly, you need to call CBS Law so we can start to investigate your case, build up your defense, identify any expert witnesses that may be needed, for example, accident reconstruction experts. And the reason we do so is so we can defend your reputation and clear your good name. So call CBS Law now at 213-800-8005, and together we'll get your life back.